Good afternoon, everybody. Thank you for joining our webinar today. I'm Jo Chatterton. I'm head of the employment team here at Fox Williams. I'm joined this afternoon by my colleagues Daisy Jones, one of the partners in our team, and also one of our fantastic associate team, Kathy Scott. It's Kathy's first HR law webinar. I'm sure it'll be the first of many. And not to forget Bailey, who is behind the scenes making the magic happen with all of the slides. Before we start, just to mention, of course, that the webinar is being recorded. We will also circulate slides after the session, so don't worry about trying to take notes of all of them. You'll get a copy of those. If you do have any questions, please pop them into the Q&A box that you'll find on your screen. We'll try and get through as many as we can. If we don't cover everything, then please do contact your usual FW contact or any one of us on the session with your question. So without further ado, let's start looking at the Employment Rights Act, which came into force last December. And this was one of the key pillars of Labour's manifesto pledge to make work pay. And it's a very substantial piece of legislation, fated by the government as the biggest upgrade in workers' rights in a generation. It's a very major reform. We've got changes in 28 different areas. It's almost 300 pages of detail if you print off a PDF from online, and it's taken 14 months to get from introduction to enactment. This is not just a few tweaks to existing rules. Some of the changes are going to have quite a significant impact on the cost and resources needed to employ people in the UK, and are therefore material matters which your business will need to be made aware of so that they can plan ahead. In terms of what we're going to cover today, we obviously can't cover absolutely everything in the time available. We've only got an hour. So what we've chosen to do is try to focus on the areas which we think will be most kind of significant for the audience this afternoon. So we're going to cover three areas. The first of those is unfair dismissal changes, and that includes looking at the new fire and rehire changes in the context of changing your employees' employment contracts. We're then going to look at trade union and collective law. Now, you may think that's not an area that's obviously associated with, I think, most of the businesses represented by this audience. But the new rules will give much greater potential access to unions, to private sector companies and partnerships. And that brings a possibility of quite a significant change in how employee relations are managed. So it's really important to flag it as an area when I think actually most of us might naturally skip over this when we're reading about the changes. And finally, we're going to look at discrimination and parental rights. And broadly for each one, what we'll be looking at are what the changes are, the impacts for your business, and what you can do now to prepare for those changes. Before we start on the detail, I just wanted to talk a little bit about the timeline. And you'll see on the next slide, which is quite a busy slide, but you'll get a copy, so don't worry about trying to read all of the detail here. But to give you an idea of the sort of implementation, because it's not the case that everything has come into force immediately. Some changes are already enforced, but other things will be coming into play during the course of the year. The vast majority of those in April and October, which are the sort of normal implementation dates for changes to employment law. But be aware that the timetable is a little bit of a movable feast. So a few weeks ago, we were talking to another organisation about these changes, and literally an hour before we did that, there were some changes made to the timetable. Some things we don't have a time for yet. So, for example, the ban on non-disclosure agreements relating to discrimination or harassment. Some of the provisions are subject to consultation. Just last week, we saw a new consultation opened on collective consultation. Just this morning, we've had some new guidance issued in relation to menopause and gender pay action plans. So you need to keep an eye out for these changes. And probably the best way of doing that is that we're going to be updating everybody through our HR law updates that we send out for free. So if you don't receive those, please do let us know and we can sign you up so that we can do that hard work for you. So with that, I'm going to now start looking at those key changes. So we're going to start with unfair dismissal. And this was, of course, one of the most talked about proposals under the Employment Rights Bill as it was. And that was the reduction in the qualifying period to bring unfair dismissal claims. And as you know, the suggestion was that this would be a day one right. But much to the relief of employers, I think, and after a lot of backwards and forwards with the House of Lords, that proposal has been watered down. And on the 27th of November, the government issued a press release that it was abandoning the proposal for day one unfair dismissal rights, adopting instead a 6-month qualifying period. And they did that really in order to get the bill through the House of Lords. But at the same time, they announced the intention to remove the current cap on compensation for unfair dismissal claims. And you'll know that that is limited at the moment to just over £118,000 or 52 weeks' pay, whichever is the lower. Now, that caught everybody somewhat by surprise because that had not been in Labour's manifesto. It hadn't been trailed in the bill. Now, the thought process behind the reduction of the time limit is to extend protection to a significant number of additional employees and also to curb the approach which the government identified as employers treating the cost of dismissing employees unfairly as simply part of business as usual during the first 2 years of their employment. This is also seen as a means of reducing the burden on the employment tribunal system of having to deal with more complex discrimination and whistleblowing claims. Now, what the government has identified, and there's probably some truth in this, is that individuals try to construct discrimination and whistleblowing claims essentially to get over the hurdle of the current qualifying period. It doesn't seem to have occurred to the government that giving 6 million new workers this new right will inevitably lead to more claims, even if those claims are less complex. And certainly lifting the compensation cap means that it's now much more likely that higher paid employees will consider bringing unfair dismissal claims because there's much more to play for. And for those of you who are in the unfortunate position of having claims ongoing against you at the moment, you will be well aware of the significant delays in the tribunal system. At the moment, we've had cases listed in some situations in 2029 and even one in 2030. So it's difficult to see how this sort of policy expectation is going to be met. But these are matters about which there will be no further consultation. They will be coming into play. So what is the impact then on your business? Obviously, there's a significant increase in exposure to claims, given that everybody that you hire after the beginning of July will qualify to bring an unfair dismissal claim in 2027 when the change comes into effect. Firstly, of course, given you only have a 6-month window, there's going to be much more emphasis on hiring people who you're confident have the attributes and experience needed to succeed in your business. There's less room for taking a chance. And I think that speaks to making sure you have robust assessment in the hiring process. Employers will also need to properly assess performance during the initial 6-month period and make timely decisions about keeping someone on. And remember, it's actually 1 week before the 6 months is up when the dismissal needs to fall in order to avoid triggering the right to bring a claim. It's going to be much more expensive to get it wrong in deciding to pass someone's probation. And what that will entail for many is better active management of performance, which means, of course, more demands placed on manager time. I think line managers also need to be made aware that once that initial 6 months is up, the flexibility to get rid of staff for the cost of the notice period is going to disappear, and there will need to be much greater emphasis on due process prior to any dismissal, and also ensuring that there is clear evidence that the dismissal was for a fair reason. So you are going to be reliant, I think, on line and team managers being afforded the time to take good, robust decisions, and also to take time to have proactive hands-on management. Hence the sort of motto that I've highlighted on the slide: hire slow, fire slow. We, of course, know that where managers are inexperienced or where they manage alongside their commercial revenue generating role, they don't always give this the attention that it will now need. So it may be that there needs to be more HR oversight and discipline required around the processes and accountability by managers. Moving on to the impacts of lifting the cap. Well, the obvious impact is the potential for substantial awards of compensation for unfair dismissal. So where someone is dismissed unfairly, as for discrimination claims, they may now be able to recover the loss of bonuses or incentives, which they would otherwise have been awarded or retained had they not been unfairly dismissed. So this makes it much more viable for your highest earners to pursue claims. That, of course, has a knock-on impact on the quantum of settlements, which will make it likely harder to achieve a settlement at a quick stage because there's much more at stake. And that means that your business is going to need to think very carefully about budgeting for greater legal spend and larger settlements. And it will also need to factor in more time for projects such as restructures, for example, or redundancies, if fair processes are going to be followed, because that is the way that you will manage the cost and the risk. And what that may mean is that could push up the cost of any insurance you have to cover you where you have claims by employees, because of course, the likely number of claims will increase, as well as the potential quantum of awards. So what can you do to prepare for this change? Well, first of all, I think it will be important for you to take a critical look at your policies and processes around hiring, around probation periods and how they're managed, how you manage the transition of new employees and integration into the business. And make sure that you make your requirements and expectations of managers in carrying out these processes very clear to them. Also think about your decision making. Is it the case, perhaps, that HR and legal need to be much more closely involved or to sign off on any dismissals, given the stakes that are in play now? I think HR or legal's involvement will mean line managers hopefully will get a better handle on the risk profile and don't make rash decisions, but also that the opportunities are not missed to take steps to mitigate those risks. Record keeping has always been crucial, but will become more so when we're thinking about managing employees around their performance and conduct. It's a common weak spot in annual reviews, in probation meetings, in manager check-ins, where often there are either no records or the manager is inclined to take the easy route of not delivering difficult constructive feedback. Think about whether it's helpful to have forms which essentially force the manager to take a view on a specific aspect of performance or give a grade, rather than just inviting general free-ranging overview, because that's going to be much more helpful if you subsequently decide that they're not going to pass their probation or you want to terminate their employment for performance reasons. And I think the expectations around the process, around record keeping, etc., is obviously an important thing to include as part of training for managers, along with introducing them to any new processes and policies that you put in place. And finally, you will need to factor into your financial planning the likely cost of settlements and claims, which, as we've said, will likely be significantly higher potentially. Moving on now to fire and rehire. You'll probably be aware of the Code of Practice, which was introduced in 2024, which provided some guidance on using fire and rehire processes to effect changes to employees' contracts and when that mechanism could be used. In short, it's supposed to be a last resort, and there's a penalty for not complying with the code, being a possible uplift to any employment tribunal award of up to 25%. Now, the Employment Rights Act goes further than that, and in addition to the prospect of a 25% uplift in compensation, there will be new restrictions introduced preventing employers from dismissing and re-engaging or dismissing and replacing employees to effect contractual variations in all but very limited circumstances. Now, this isn't a practice that most of our clients tend to favour for obvious reasons. It's never a good idea for employee relations. But in difficult economic times, we can see this option being considered, particularly where there are stubborn employees who won't budge on agreeing drops in pay or increased hours for the same pay, for example. I think also if employees know about this enhanced protection, it may make them feel more confident about resisting change because they know that it creates exposure for the business. So these changes could limit the flexibility that you have in restructuring or harmonisation and cross-control projects. They could give you enhanced exposure to claims because dismissals in a fire and rehire process will become automatically unfair. And the defence is open to you to any such claims are going to change. So in terms of what's going to be happening, well, it will become automatically unfair to dismiss an employee where that dismissal is because the employee has refused to agree to what's called a restricted variation to their employment contract. It will also be unfair to employ another person or re-engage the employee on new terms, which include a restricted variation, or to enable the employer to replace the employee with another individual who is not an employee of the employer. So the definition of restricted variation is obviously important. These are variations to pay or pensions, also to working time, working hours, shift variations, or a reduction in holidays. And it will also cover at the introduction of variation clauses. So clauses where the employer wants to reserve the right for themselves to make changes unilaterally to certain terms and conditions of employment. Now, there is some debate about this definition. At the moment, the government is considering in consultation whether expenses and benefits should be included, and also whether to limit the variations in shift patterns to only very significant changes rather than de minimis. So, for example, if you moved the employee from working day shifts to night shifts, that would be a restricted variation. So there may be a little bit of movement in terms of what this definition really covers. Now, it's important to note that the new rules won't prevent changes being made to contracts with agreement with individual employees or through collective consultation. But it's not the case that variations which don't fall under the definition of restricted changes are going to be automatically fair. You will still need to act fairly in introducing them, and the types of factors that are likely to be looked at will be whether you consulted with employees about the change in a meaningful way and were any incentives offered. Now, there is an exception to this, which is where the employer can demonstrate financial difficulties. But not only that, they have to show that the variation is necessary to overcome or mitigate those difficulties, and that the dismissal or re-engagement is unavoidable. In other words, it's a last resort. But this is a very high bar. Effectively, there needs to be a kind of serious and imminent risk to the solvency of the business or the ability to carry out the business. And even then, this is an exception. It's not a full defence. Again, we come back to the question of whether in the circumstances the dismissal was fair. And again, it's looking at whether there has been consultation and whether there have been incentives offered. We are expecting some more guidance in regulations around an updated statutory code of practice to sort of flesh out sort of other factors which will be taken into account when assessing that fairness. So in terms of what are the key impacts here, I think there will be a kind of reduced ability potentially to make changes to contracts. And I say that because what you may find, even if you ideally want to avoid fire and rehire, is that, as we said, the employees may feel they have more leverage because they know it's going to be risky for you to adopt this stance. So it may be that this new legislation makes it much harder for you to get agreement from your employees. There is a particular risk. So if you have people on fixed-term employment contracts which come to an end, that is counted as a dismissal, even if it's the end of an agreed fixed term. And if you replace them with a contractor on different terms and conditions, you may inadvertently trigger a claim for automatic unfair dismissal. So that's one to watch in the future. But if things go wrong, because this is an automatically unfair dismissal, it is a day one right in this case, and the stakes are going to be high because of the lifting of the compensation cap. And potentially there's more complexity in the business because you may have people, particularly if you're an acquisitive business, on different terms and conditions rather than being able to standardize the contracts that your employees are employed on. So what can you do to prepare? Well, I think the key thing is if you're thinking about making changes, do it now. So check your current contracts and templates and think about whether you need to update them, including to include in them the flexibility to make some changes now, because that's going to become a restricted change. You can use your new terms for all new joiners, but you may find that there's sort of more admin around changing terms and conditions in the future. So it's really helpful to consider when you're faced with this exercise of changing for existing employees, what levers and incentives you can pull to secure their agreement, because that will be the priority. And many of you will already link changes to contracts, etc., to pay and bonus time. And it may be that in any exercise in harmonising terms and conditions, you need to get comfortable relying on implied consent to avoid a fire and rehire or fire and replace scenario. It's usual if you make changes to pay that those will be deemed to be accepted fairly quickly. So there is a little bit of uncertainty you might need to live with, but that might be worthwhile because of the management of the risk. So that's all I've got to say. I'm going to now hand over to Daisy.
Thanks ever so much, Jo. So I'm going to spend the next section of today's webinar talking a little bit about some of the changes under the Employment Rights Act that impact collective bargaining. And the first one I'm going to talk about is collective redundancy. So just to bring us all up onto the same page, at the moment, if you as an employer are proposing to make 20 or more people redundant within a single establishment, so classically that's at one office or one physical site, and you're going to do that within a 90-day period, you have to go through a collective consultation process. And what that involves is electing representatives, providing those reps with certain prescribed information, doing a form of macro consultation with those reps before you get into the individual consultation. And there are also timetable implications as well, because there is a minimum period of between 30 and 45 days between starting the collective process and the date on which you can actually start to make your redundancies. And if you get that wrong, so if you don't collectively consult when you're meant to, or you don't do it sufficiently, employees can have claims for what we call protective awards, and they are capped at 90 days actual pay per affected employee. Now, there are two proposed changes that the government is running under the Employment Rights Act. The first is a change that will come into force as of next month, so coming up very quickly on the timeline. And that is to change the financial exposure for failure to collectively consult. So rather than it being a 90-day award, the government is going to double that. So employees could claim up to 180 days pay if you don't go through collective consultation where you're meant to. And on top of that, tribunals will also have the ability to uplift an award by up to 25% where you unreasonably failed to consult. So that is a very significant increase in the financial exposure of getting it wrong. And one thing, we have a number of clients, particularly in the financial services sector, who, if they're required to collectively consult, will often prefer to buy out the collective award as part of their enhanced redundancy package. If you're planning on doing that, obviously, please factor in the fact that the financial cost of that approach is really going to be an awful lot more expensive. So even in circumstances, industries and employers where the collective consultation process might be a little bit alien, you may find that from a cost perspective, you are going to have to go down that road rather than the classic sort of buyout approach. Now, on top of the increased financial exposure, the government is also going to be expanding the triggers for when collective consultation will be required. So we're going to keep the existing trigger of 20 or more redundancies in a 90-day period, but the government is going to introduce a further threshold, which will effectively look at the aggregate number of redundancies across the business. So rather than being focused on site-by-site redundancies, which we have classically In the establishment definition, employers are going to have to look at redundancies across their business. Now, we don't know at the moment what threshold the government is going to implement. A consultation opened earlier this week, I think. It closes on the 21st of May. And there are various proposals as to how they might look at the threshold, whether it's a fixed number, a percentage of workforce, etc. But that is something I expect we will get more clarity on into summer, autumn of this year. And the new threshold is proposed to be introduced next year. So those are the changes, but what should you be doing to prepare? Well, I think if you're a multi-site employer, so if you operate a business across a number of offices or geographies, and you're planning on doing multiple exits across those multiple sites, it might be sensible to think about accelerating those exits through to 2026, because redundancies that might avoid a collective process this year may end up being caught by the new aggregate business threshold that's going to be introduced during the course of next year. And that is, of course, on top of the other reasons you might want to exit staff this year in terms of the changes that Jo has talked about on unfair dismissal. The other thing you might think about introducing, particularly if you have multiple sites which operate with a reasonable degree of autonomy, is introducing a form of central tracking system that will capture the exits that each individual site or office is proposing, so that you can see quickly and easily if you're likely to cross the threshold when we have this aggregate business threshold for the collective process. And aligned to that, it might also be sensible to have centralised discussions around proposed redundancies where you're a multi-site employer, so that you don't end up in a situation where you inadvertently trigger collective process without knowing, because another office or another site is doing some similar redundancies at the same time. And that where you do go on to have a collective process, you do that intentionally and strategically. Now, the final thing you might think about, and I should sort of caution, I think this is only going to be relevant to very few employers, is if when we get the new threshold test announced by the government, you consider your classic redundancy cycle. If you look at that and think we're going to have to be going into collective process an awful lot just because of the way you operate your business, it might be worth thinking about a permanent employee rep forum and having reps on that forum specifically trained to deal with collective redundancy consultation, just to make the collective process a little bit more streamlined and to remove that initial step in terms of electing reps. So we're now going to move on to talk about trade unions. And as Jo said at the beginning of the webinar, you may be thinking, well, I can just switch off with these slides because frankly, it's not going to impact my industry or my business. I think that is potentially kind of misconceived, because a lot of the intention of the Employment Rights Act is around helping unions to access and get recognition in sectors and in businesses where previously they've really struggled to gain traction. And the government proposals are many in this area, but I've picked out the key ones that I think are really important for you to understand on this slide. So the first change is coming into force in October of this year, and that is introducing an obligation on employers to give employees a written statement which tells them that they have a right to join a union. It should tell them a bit about how trade unions operate, and also it should signpost them to what's likely to be a government page with information about unions they might join. So that is something that will need to be given to new joiners, and you'll also have to make a similar sort of statement available either on your intranet or on notice boards internally as well. So that's an October this year change. The next change is actually quite seismic in terms of trade union access, and this is also a change that's coming into force in October. And this is the right that unions are going to have to request access to your workplace. And they can request that access to recruit workers or to help them facilitate collective bargaining. And they can have access either in real life. So if you have people coming physically into an office, they could ask to come in to the office and in a sense to have a little stand with information and materials available for your employees. Or they might be able to do that virtually. So if you're typically working in a remote environment, they can ask for access in that virtual way. Now, there is an exemption for small businesses, but those are businesses with fewer than 21 employees. So if you're over that threshold, be mindful that from October 2026, you may have unions asking for access. And we certainly have some clients, including clients in financial services, who have already been approached by unions in advance of this obligation, asking about representation and access. So I can certainly see a world in which, if you have a business that is potentially vulnerable to unionisation, we have unions proactively approaching and using this access rights to improve their membership and potentially get to recognition. Which obviously brings us on to how a union can get recognised. And union recognition is important because once a union is recognised, they can effectively organise lawful union activity like strikes, work slow, refusal to work longer hours, etc. So it gives members of the union a lawful route to be more difficult to object to potential changes that you might intend to introduce. And this recognition requirement is coming right down. So one of the reasons that unions don't tend to be recognised by a lot of private employers at the moment is that it's actually quite difficult for them to get over the thresholds required. Now, from April of this year, we're going to have a real change in position on this. The approach that will have to be taken is that a union will need to identify what they want to have as their collective bargaining unit within an employer. So that might be the whole of the employer's workforce, or it could be a part of it. So you can see a scenario where a union thinks, well, I don't think I'm going to have much luck with front office staff, but back office staff, I think there's an opportunity for us here. So they identify their collective bargaining unit that they want to try and get recognition for. And the first hurdle is they've got to get membership in that unit of between 2 and 10%. So if they identify a bargaining unit that's made up of 100 people, they'll have to get between 2 and 10 of those people to join the union. And that threshold is still being determined, although the change is coming in April. So watch this space for confirmation. Once the union gets that level of membership, they can then apply for formal recognition. And that will typically end up being balloted. And what that means is that the bargaining unit that they're looking to represent will be asked to vote either in favour or against recognition. And the union just needs to get a simple majority of the bargaining unit who actually vote to vote in favour. So again, if we take the example of 100 employees, if only 20 of them bother to vote, the union only needs 11 to vote in favour. So actually, you can certainly see a scenario where a union petitions for access, comes into your business, sells out, their services and why they might be advantageous for employees, particularly in environments where the economics are going to be challenging. Perhaps businesses are going to think about changes to pay, changes to hybrid working. So they set out their stall, they advertise membership, they get those reasonably low levels of membership, and you might find without very many of your employees needing to be interested, they could get formal recognition. So given that change in landscape, what could you do to prepare now? Well, I think the first thing is really to just audit your business, because not all businesses will be attractive to unions. They're plainly going to want something in terms of size because they are wanting membership fees. So are you of a certain size? And do you think you're operating in an industry or with an employee demographic that might be vulnerable to unionisation? So I'm particularly thinking of larger employers that might have quite classically sort of significant back office functions. I can see that being somewhere the union really tries to gain traction. Maybe if you have big call centres, low paid employees within your matrix. So do you think you're vulnerable? If you think you're vulnerable, what are your staff relations like? Take a temperature check. Are people generally happy? What do your engagement surveys show? Because if you have a business that's potentially vulnerable to unionisation and staff relations are not great, you might find that you're exactly the type of employer that a union will target for recognition. And if you're in that space, one thing you might think about doing is actually getting ahead of the unionisation piece. So you could think about introducing a permanent employee rep forum so that employees feel like they have a voice and they're able to engage with you on important issues. Because if employees feel like they're getting that recognition from you within the business, the actual sort of lure of the union, for which they'd have to pay membership fees, becomes kind of less attractive potentially. And then the final administrative point to note is obviously you'll need to update your documentation. So that's particularly in relation to the October changes where we're going to have to give a statement confirming rights to join a union to your employees. So the final thing I'm just going to talk to you about is the Fair Work Agency. So this is a new enforcement body. It's going to be introduced in April of this year, and it's going to have quite wide-ranging powers, although some of the precision around the powers is still to be confirmed. But I've got on the slide the kind of key areas where we're likely to see them being most activist or most interested. So the first is around enforcing failure to pay statutory payments. So that is things like national minimum wage, holiday pay, or statutory sick pay. If they find that you as an employer are not paying those sums appropriately, they can bring proceedings against you, and actually you can be subject to a penalty of up to 200% of the sum due. So there's some financial teeth there. Now, I expect a lot of you on the call are thinking, well, you know, we're reputable employers, we pay national minimum wage, we pay holiday pay, we pay sick pay. I'm sure that is right, but we do have some clients who sometimes inadvertently trip up on these issues. So just to give you a few kind of classic examples, we have had clients where they have employees that contribute to pension under salary sacrifice arrangements. And if you do that, the way the salary sacrifice works is that you actually bring down your level of salary, so your actual wages for the purpose of the minimum wage legislation. And what sometimes happens is that employees approaching retirement will want to put a lot of money into pension. And so they really, go to town on the salary sacrifice arrangement for pension contributions. And we have had employers where this has happened in such a way as to bring the employee's normal salary below national minimum wage. And it's no defence to say this is completely consensual. It's no defence to say that the overall value of the benefits exceeds national minimum wage. The legislation here is very stark. It is about salary paid. So that is an area where we found some inadvertent non-compliance with the national minimum wage requirements. Similarly, holiday pay has been, in recent years, a topic of great debate as to what should and shouldn't be included. We've got quite a settled legal position now, but I think there is still scope for variance or misunderstanding as to what ought to be counted in holiday pay when it comes to irregular hours workers, people getting lots of pay in commission or through bonuses, and whether that's actually translated into what their holiday pay ought to be. And that doesn't necessarily mean employers are trying not to pay the right levels, but sometimes I think there's still a bit of misunderstanding or lack of clarity on that point. So it is something that I think everybody should be mindful of. The other thing the Fair Work Agency is going to be able to do is effectively assist employees with bringing litigation in the employment tribunal. So they're able to bring proceedings on behalf of workers. They're also going to be able to provide legal assistance for employment-related proceedings. So they'll be facilitating that litigation route for certain employees. And then finally, in terms of the costs, the idea is that it's largely self-funding model insofar as they'll be able to recover their enforcement costs from non-compliant employers. So that's going to be introduced in April. And so let's think about what you might sensibly do to prepare for that. So I think the first thing that I'd advise is just to audit your businesses again. Think very carefully about your pay practices, particularly in light of what I've highlighted around salary sacrifice arrangements and holiday pay. So get comfortable that you're compliant and you don't have any inadvertent breaches. Now, aligned to that is record keeping. That is something that's always important when we're talking about protecting employers from potential claims or complaints. So if you were to be audited by the Fair Work Agency or they were to make some inquiries, are you able to show them that you're compliant? So make sure that you've got those records that demonstrate compliance. And then linked to that is particularly for those of you who work for larger employers, maybe with potential complex pay practices, think about having some kind of compliance project team who can own the space, own compliance, and are ready to explain to the Fair Work Agency, if necessary, how you are compliant. And then the final thing I wanted to flag is look again at your internal complaints processes, your speak up avenues. So that's typically going to be your grievance and whistleblowing processes. And that's just thinking about the ability of the Fair Work Agency to bring complaints on behalf of workers. Because ideally, if you have good internal speak up processes, the risk of individuals complaining to the Fair Work Agency and bringing them into your business to have a good look around as to what's going on should be lower. So just make sure that those processes and those policies are working well. And with that, I'm going to hand over to Kathy, who's going to talk me through some of the family-friendly changes.
Thanks, Daisy. As she just said, I'm going to start with an update on the parental leave changes. The first change is that both paternity leave and unpaid parental leave will become day one rights for employees. In relation to paternity leave, this will apply to parents of babies with an expected week of childbirth or with babies born on or after the 6th of April 2026. And the day one right to take unpaid parental leave will also apply from the 6th of April this year. Currently, paternity leave requires 26 weeks service and unpaid parental leave requires 1 year's service. So these changes will bring those entitlements in line with other types of family leave. It's also worth noting that this change only applies to leave, but not pay. Therefore, statutory paternity pay still has a 26-week service requirement and parental leave remains unpaid. When we're thinking about notice requirements, normally for paternity leave, the second parent must give notice of the entitlement to take leave at least 15 weeks before the expected week of childbirth, and then specify the actual dates for paternity leave 28 days before the leave starts. However, with these changes, the 15-week requirement will fall away, and there will also be a transitional period from the 18th of February this year up until the 25th of July this year, where newly eligible employees don't need to give that 15 weeks notice, but they'll still need to give the 28 days notice of leave starting. This transitional arrangement will, of course, fall away after the 25th of July. As a final point, fathers and partners can now also take paternity leave and pay after shared parental leave and pay is taken. Previously, this wasn't allowed. In terms of the impact on your business, it's not likely to be material, but it will likely lead to a greater number of family leave absences and therefore requires more continuity planning. The notice periods to take the leave may also make such planning more challenging. And as a final point, arguably, it could also create a greater expectation on employers to provide more generous family leave policies in the statutory position. For example, a day one entitlement to enhanced pay. So what can you be doing to prepare? Review and update your employee handbooks, make your managers aware of the changes, and communicate to employees what the expectations are in terms of notice requirements and helping the team plan. Moving on, the next key topic to discuss is the changes to the duty to prevent sexual harassment. I'm sure you'll already be aware of the changes that came in October 2024, which introduced the new duty to prevent sexual harassment. The current duty on employers is to take reasonable steps to prevent sexual harassment, including the advised step of undertaking a risk assessment. However, the new duty coming in from October this year is for an employer to take all reasonable steps, a seemingly higher threshold. The government will have the power to specify in regulations what will be regarded as the reasonable steps an employer should take, and we're expecting these regulations to be published in October this year. We are expecting all reasonable steps to include risk assessment, prevention of sexual harassment policies and action plans, and measures relating to reporting procedures and how complaints should be dealt with once received. The government is also indicating that it will consult on the prescription of reasonable steps before they come into force. It's clear from these changes that the expectations on employers are higher, and employers should be taking this as a reasonable opportunity to consider if they already have the relevant policies, procedures, and assessments in place, or if further work may be required. Whilst this isn't a standalone claim, any breach of the preventative duty can result in the Employment Tribunal awarding an uplift of up to 25% to the claimant's total compensation for breaches of the Equality Act. Given that compensation awarded in respect of a discrimination is uncapped, a 25% uplift could prove to be very costly. The other change is that the Employment Act also amends the Equality Act to introduce an obligation on employers not to permit harassment of their employees by third parties, such as clients, suppliers, and other vendors. An employer permits a third party to harass an employee in circumstances where it's shown that the employer failed to take all reasonable steps to prevent the third party from harassing their employee in the course of their employment. It's also notable that this duty would be breached regardless of if the employer had knowledge of the harassment. This obligation is particularly onerous for employers operating in sectors where their staff frequently come into contact with third parties, such as hospitality and retail. Another point about this change is that it's not just limited to sexual harassment, but any form of harassment linked to any of the following protected characteristics: age, disability, gender reassignment, race, religion and belief, sex, or sexual orientation. And in line with the current definition of harassment under the Equality Act, it doesn't apply to the protected characteristics of marriage and civil partnership status or pregnancy and maternity. Again, we appreciate this is a relatively broad obligation, but employers do have a defence of such liability if they can show they took all reasonable steps to prevent such harassment. Moving on, another change relating to sexual harassment is whistleblowing. Raising a concern that sexual harassment has occurred, is occurring, or will occur may constitute whistleblowing, also known as making a protected disclosure, and therefore a person that's raised concerns may benefit from protection from detriment and/or dismissal. This change is expected to come into force on the 6th of April this year. In reality, this doesn't change the legal position very much, as the allegation about sexual harassment is likely to have fallen under the definition of protected disclosure already, either as a breach of a legal obligation or in severe cases of harassment, a criminal offence. But bringing in this explicit legislation dispels any ambiguity on this. What is interesting is that specifically labelling it as a protected disclosure paves the way for employees to apply for interim relief in the event that they are dismissed after having made a complaint regarding sexual harassment. Whether a claim would be successful will still be subject to the usual tests as to whether it constitutes a protected disclosure, such as 1, the individual having a reasonable belief that the information showed wrongdoing, and 2, that the disclosure is in the public interest. This would exclude the context of interpersonal disputes or consensual relationships. And lastly, on this slide, NDAs. There is an additional provision introduced under the Act which will void any contractual provision that purports to prevent disclosures or allegations of relevant harassment or discrimination. This is, of course, considerably wider than just an allegation of sexual harassment, and there wouldn't be the need to show that it qualifies as a protected disclosure. As Jo mentioned at the start, it's currently unclear when these changes are coming into force, so watch this space. Moving on then to the impact of these changes. Employers now have to hold themselves to a higher standard, but hopefully the increased obligations and prescribed reasonable steps to prevent sexual harassment will help avoid discrimination claims arising in the first place. Also, if we look at matters more cynically, there is a potential for the duty to be weaponized by employees who have claimed to be harassed by third parties. This will inevitably lead to some debate about what constitutes all reasonable steps, and it remains to be seen how pragmatic the tribunal will be in approaching such claims. Fourth, it is difficult to control the behaviour of third parties, even with a number of protected measures in place. Whilst this is a UK obligation, cultural differences between the UK and overseas branches may cause some tension. And similarly, there's a risk of tension with clients and suppliers who don't comply. Employers will need to assess whether they should stop working with the client that didn't comply, for example, or even immediately terminate an engagement with a supplier where there had been a more minor conduct that could be deemed sexual harassment. There will, of course, be a bit of a balancing act here between the fairness of the relevant parties. It will also be more difficult to keep sexual harassment allegations confidential, which of course can have reputational impacts, but this could be exploited by individuals in settlement agreements as well. And lastly, it may change how employers investigate sexual harassment complaints, which will now fall squarely within the scope of their whistleblowing policies, and there will be additional considerations for listed companies and those in the financial services sector. So what can you do to prepare? Firstly, review your existing policies and practices. Do you need to update your risk assessment or provide mandatory training to your employees and specifically your managers? 2, consider whether further reasonable steps could be taken, specifically considering any previous incidents that have occurred, such as at work socials, client events, or employee travel to different branches or offices overseas. For those on the webinar with offices globally, consider if you have any staff based outside the UK, but that frequently visit the UK and whether they may also need specific training. And lastly, be clear to clients and suppliers and third parties of your expectations when they're interacting with your workforce. As a final point, we appreciate this can all sound quite onerous, but the requirement is to take reasonable steps, and the tribunal will consider the size and resources of the employer when assessing what's reasonable. So as my final topic, I wanted to touch on equality action plans. Under the Act, future regulations are to be implemented that will require employers with 250 employees or more to develop and publish equality action plans. The action plans will be required to cover what employers are doing to address the gender pay gap in their workforce, how they're supporting employees through menopause, and thirdly, outlining the steps they're taking to reduce the risk and prevalence of sexual harassment. After the first publication of an employer's action plan, it will not be required to publish information more frequently than every 12 months. The government anticipates bringing these provisions into force on a voluntary basis from the 6th of April 2026 and on a mandatory basis from the 4th of April 2027. The government also intends to set up a new equal pay regulatory and enforcement unit to deal with the equal pay enforcement in the forthcoming Equality, Race and Disability Bill. Additionally, the government is amending its existing gender pay gap reporting service digital platform to include a reporting mechanism to publish a list of organisations with at least 250 employees that do not submit an action plan. Essentially, this is a naming and shaming tool. And hot off the press, yesterday, the government published guidance for employers on creating these action plans. We are reviewing this guidance at the moment and we'll be producing an HR law update with further information on what this guidance details. So, what is the impact of these changes and what can you be doing to prepare? In terms of the impact, employers will be held to account on proactive steps taken to improve equality. Query whether it will be approached as a box-ticking exercise or a genuine opportunity to improve gender equality. It may also become a point that claimants make reference to as part of any sex discrimination claims. For example, if an employer's action plan is not published, or if it is published but then not followed. And lastly, employers may come up with aspirational rather than committed plans, i.e., we will work towards the goal of X rather than saying we will do Y. So what should you be doing to prepare? 1, start coming up with action plans in these areas now so that you're ahead of the game. Even if not fully formed, it will help the company establish where the gaps are. 2, feed these discussions into your D&I strategy, as we do appreciate that often DI strategies span several years. Thirdly, employers can start reporting early now on a voluntary basis. Optically, this looks good for recruitment and reputation, but it also helps with future compliance. And lastly, consider where equality action could be input into performance metrics. Right, I appreciate we've thrown a lot of information at you, so I won't go on any further, but thank you for listening and for hanging on right until the end. I think we should have a couple of minutes now for any questions before we finish.
Thank you, Kathy, and thank you, Daisy. Yes, a few questions to pop in. The first one is whether with the changes to the unfair dismissal, do we envisage employers resorting to changing the duration of probationary periods in contracts from 3 to 6 months? I think the answer to that is not necessarily. If you still think that 3 months is sufficient time to assess an individual, then I suspect employers will stick with the period that they've got. I think in terms of extending to 6 months, you're probably better advised to extend to a slightly shorter period, maybe 5 months, because of course you've got to make sure that the dismissal takes effect in advance of the 6-month expiring, in fact, 1 week before that. So, we may see some changes, more related to that than to sort of taking up to the full 6 months, if that makes sense. We had another question about whether a change in hybrid working would be considered a restricted variation. No is the answer to that, unless, of course, there was a change in shift pattern or working hours associated with that change. But it's not the case that changing the location of work would be falling under the current definition, as we understand it, of restricted variation. We've also had a question on whether, based on the changes to unfair dismissal and collective consultation, we think that asking employees to sign settlement agreements when offering a discretionary enhanced redundancy package as part of exits is going to become more common, even where a fair and reasonable consultation process has been followed. I think probably for more senior staff, because there is more to play for them. And so if they are losing valuable incentives, longer term incentives, for example, under the rules of the scheme, you might want to make sure that they've signed up to say that they accept whatever enhancement you've given them in full and final settlement, even of any unfair dismissal claim, which might seek to capture those losses. In relation to kind of more junior employees, the normal rules apply around mitigation and how tribunals are going to work out the value of claims. So if you have lower paid employees who might be able to find a job very quickly, it's not necessarily the case that this is a sort of pot of gold for them. The way that their compensation will be worked out won't change. And so for those employees, you might consider that actually it's better to continue in a practice of not having settlement agreements, because the risk and cost is relatively low. Daisy, a few questions I think that you were going to answer.
Of course, I know we're sort of out of time, but just for completeness, we have a question about the 90-day period for collective consultation. So that starts from the date of dismissal. So we're typically in collective consultation, when we're talking about dates, it's dismissal date that is the important thing. So it's not the date of being put at risk, it's actually when the employment ends. So that is the look back period or the look forward period that you need to be mindful of. Dismissal date, not at risk date. We had a question about whether the clients I spoke about who'd had approaches from the union were larger scale organisations. Yes, the answer to that is yes. They're organisations who have upwards of 2,000 employees, so you can certainly see why unions are interested in them. But there might be a bit of a trickle down to slightly smaller employers, but I think we're still most likely to see unions focusing their attentions on those big employers where they think they're going to get the most return. For a question about, does the minimum wage issue mean that we have to say no to employees who ask to make large salary sacrifices into their pension schemes? It doesn't mean you have to say no, as long as the residual salary that they're left with is above the national minimum wage requirement. So they can drop it right down, but you do have to make sure that it continues to be above national minimum wage. We have a question about upcoming changes with regards to statutory redundancy pay. There are no proposals to change the statutory redundancy pay calculations, other than, of course, the fact that weekly pay, which is used for the calculations, is revised year on year in April.
Thank you, everybody, for listening. I hope you found that really helpful. If you do have any questions, please do direct them our way. And otherwise, have a lovely afternoon. Thank you.